Good evening, everybody. Thank you for joining us tonight.
Sorry, one sec. Could you all hear Karen? Paul, can you hear Karen? Okay.
Can you hear me?
Give me a thumbs up if you could hear her. Paul.
Okay, I can't hear it too well.
All right, so she's gonna come over here. Karen,
Yes.
can you hear her now?
Can you hear me, Paul?
Yes,
Okay, thank you. So we're gonna start our presentation. Good evening. Thank you all for joining us. My name is Karen Hertz. I'm an employment lawyer here in Westchester County. And this presentation is being brought to you by myself and a colleague of mine, Brian Lawler, who we'll learn about a little bit more, who has introduced this area of the law to me, Userra. I don't know how many of you all know exactly what Userra is, but it is the equivalent of the law that protects military people from being discriminated against in their workplace based on their military service or status. I can't hear, and this isn't.
Okay. Let's go to the next slide.
Oh, you're gonna do it.
Yeah. Okay, let's see why this thing is up.
Okay, this is just the poster from tonight's event. If anybody didn't get it, this is what it looked like. So thank you for attending. Next slide. So Userra is the Uniformed Services Employment and Reemployment Rights Act. And this is the poster with all the information on what Userra does for people and how it protects employees. And if you go to the next slide and you take a picture of the QR code, you can have that information on your phone. So just for fun and games, I'm gonna do it. And there, it came up on my phone.
Can you show it one more time?
Sure. Okay, next slide. So Userra was passed in 1994. The history is that it is the third in a long line of veterans protection statutes that started in 1940 that protect military service members and veterans from employment discrimination on the basis of their service. Userra protects members of all the armed forces, the National Guard, and other uniformed services, including the National Disaster Medical System and the Commission for the Public Health Service. Userra ensures that members of the armed forces, past and present and future, are not discriminated against or disadvantaged in their civilian careers due to their military service, and ensures that upon return from duty, they are promptly returned to their civilian job. Userra protects employees who are military men and women from negative job action. And negative job action can be firing, it can be demoting, reduction in benefits or pay, transferring to another area, and also refusing to hire. So job applicants are also protected under Userra. Userra, again, as I said, employers cannot discriminate against any member of the uniformed services in their civilian jobs based on their service. And Userra protects military leave for up to 5 years, so that your employer, if you were deployed, would have to hold your position open for you for 5 years. Most of the time, that's the case. And they must restore all of your benefits upon return from duty. And they can't fire you while you're out on military leave. If anybody has questions, we're gonna have Q&A at the end. I don't want to sound like I'm reading off of this presentation. I worked very hard on it, so this isn't just me reading to you. This is the law, and we're gonna get to more interesting and interactive stuff in a little bit. So every employer, so Userra is not a paid leave. It's unpaid. It is it applies to active duty members that leave for service in a conflict, war, or other action. It's annual leave for National Guard or reserve training, drills, and other short-term related activities, inactive duty training drills, national emergencies, and in certain circumstances, funeral honors, and additional training certified the service secretary. Userra applies to all employees, full-time, part-time, hourly, and probationary. It does not apply to independent contractors. As long as you're an employee, your employer cannot discriminate against you based on your military service obligations, despite the type of employment that you have, even if it's part-time. If this works. Okay, got it. So Userra applies to all employers, public and private. And we'll talk a little bit later about some of the public employers that believe that they were immune from Userra, and the Supreme Court has spoken out on that. And my colleague Brian Lawler was lucky enough to be the advocating attorney to make that happen. So in order for Userra to protect you as an employee, you also need to, there's things that you have to do in addition. You have to give notice to your employer regarding any orders that you receive. And it's considered legally, you need to give timely notice, either verbally or in written form. And timely is a question, you know, if it's under an emergency, maybe it's not as timely as you would like, but you know, you have to let them know. If an employee doesn't notify their employer of their orders, Userra may not protect them. It's important also to know that you do not have to ask and request leave for military service. If you get orders, you're going. There are 5 criteria for Userra protection. So you have to have left a civilian job. Yeah, obviously, we discussed you have to give your employer prior oral or written notice. The max amount of time that you can be out is 5 years. You must have been released from service, with a positive discharge. And you have to have made a timely application for reemployment. So when you return from service, you have to very quickly notify your employer you're back and you want to get back to work. What do you need to give your employer? They can only require documentation of military service periods where your leave is longer than 30 days and can demand it only upon your reemployment. Most people do wind up giving their employer notice when they get their orders because they want to make sure that, you know, everything's kosher, but technically this is the procedure. And when can you know, sometimes you can't do it prior to leaving. Usually that's the better practice, but your employer can't demand that you provide the documentation before you leave. You may not have time if you're going out in an emergency situation. And again, I stated to you that the employer has to hold your job for 5 years. There are some exceptions, and if you have questions about that, we can talk about that after. I want to now go over some really interesting and blockbuster law-breaking Userra cases, and this one is called Torres versus Texas. Leroy Torres was enlisted in the U.S. Army Reserve in 1989, and he was also a trooper with the Texas Department of Public Safety. And he served until 2007, he was deployed to Iraq. He was honorably discharged in 2008, and he sought reemployment by the Department of Public Safety. He did, however, have a lung condition that he acquired in Iraq, and he requested that his employer put him in a position different from the one that he held before. They offered him only a temporary duty offer, and he declined it. Torres sued the Texas Department of Public Safety, alleging that they failed to offer him a job that would accommodate his disability. So it was a disability, but it was also his military status. And that in and of itself violated Userra, which prohibits an employer from adverse action against an employee based on their military service. So what happened with this case? Texas was of the position that they are a governmental entity and they have sovereign immunity, and that therefore Userra doesn't apply to them. But the trial court ruled in favor of Leroy Torres, and then Texas appealed. On appeal, the appellate court reversed the decision. However, last year in June of 2022, the Supreme Court of the United States ruled in favor of Leroy Torres and held that Texas couldn't get around Userra by claiming its governmental entity and therefore immune with sovereign immunity. And so this was a huge victory for employees all around the world, but especially military employees. And I'm really pleased to now introduce you to Brian Lawler, who is the attorney who represented Mr. Torres at the Supreme Court. Brian is on the screen. He's going to be speaking in a minute. I'm just going to tell you a little bit about him. He received his bachelor's in political science from Tulane University and graduated from the University of San Diego Law School. While attending law school and before law school, he served on active duty in the Marine Corps as a weapons and sensors officer in the FA-18D Hornet, including one tour as an instructor in the Hornet. From 2001 until he retired in 2018, Mr. Lawler was active in the Marine Corps, where he held the rank of Lieutenant Colonel. Most excitingly to me is that Mr. Lawler has recently been invited by the House Veterans Affairs Committee to assist in amendments that are being made to the Userra laws right now. And so without further ado, I'm going to introduce you to Mr. Lawler.
For who's watching on Zoom or who's in person, but first of all, thanks, Karen, for the kind introduction, and thank you to the VFW for having me and Karen to sit here and talk about something that maybe some of you knew some about, maybe something you didn't know anything about. Hopefully, what we've discussed so far and will continue to discuss is informative for yourselves, for friends, for colleagues. And whether you're on the employee side, eagerly awaiting what we're going to tell you about your rights, or on the employer side, eagerly waiting us to tell you how people like me won't sue you for doing things that are unlawful, the way it's probably going to be beneficial. We'd like to keep it light and open. We said we'd reserve the questions until the end, and we certainly will. I'll let Karen pick back up with some more case studies, and I'm here to field any questions. This is Karen's show. I'm just kind of the guy in the corner who gets to wave and smile and I'll sit back down. So without any further ado, Karen, thanks again, and back over to you.
Thank you, Brian. You are ever so humble. We are going to talk now about a few, Andrew, it won't adjust, a few cases that are real. Everything that we talk about here is a true case. So I'm going to ask you guys to participate. So I need you to wake up, okay? We are going to talk about a guy named Tom. Tom was a sergeant in the Harper Valley Police Department. He's also a reservist in the US Army. He receives mobilization orders in April 1st for April 5th mobilization. He reports this to his supervisor, Captain Morgan. And Captain Morgan says, not if I don't approve it. Okay, what do we think about the supervisor telling him he can't go unless the supervisor, Captain Morgan, approves his leave?
So did he provide the right documentation, or did he just verbally?
Does he need to?
He needs to provide his orders in writing, right? Did it, well, first of all, he cannot be denied, right? But then in order to protect himself, he must provide written orders.
Right, but he doesn't, but the employer does not have the right to refuse it,
Right,
and they can't take adverse action. That means they can't threaten to take adverse action. They can't take it. They can't say, if you take your leave, you're fired.
right.
Or you have considered to have abandoned your job.
So my question is.
We're going to save the questions.
Oh,
though.
sorry. Okay.
Now here's another one, and these are all real cases. So Mike is a financial accountant, and he advises clients. He has a book of business of about $9 million. Okay. Mike is called to duty after an attack on U.S. interests overseas. When Mike comes back, he requests of his employer to reinstate him to his old position. The company takes more than 4 months to reinstate him. And they offer him a third of his prior salary, along with a list of cold call prospects and not the list of, clientele that he had. So the company takes more than 4 months to reinstate him. Mike sues over the fact that it took 4 months for them to reinstate him. The company says, well, we were busy, but we did offer him reemployment eventually. What do you all think about that?
That's violating his Userra rights.
Because that's not prompt reemployment, correct?
Right.
He also sues over the fact that he's getting a third of what he was making. And that essentially what happened was because they offered him such an inferior position that he wound up having to leave, which is a legal term called constructive discharge, which is you quit, but it's as if you were fired because they gave you kind of no choice. And the company says that he's paid at the same rate, but the rate is commission, but that's not the case. And he has a chance to recover his losses. So who wins on the issue of the 4-month wait?
Mike?
Mike wins.
All right.
Because he wasn't promptly reemployed. Mike also wins on the question of pay reduction because the company claimed that it was the same position, but the same position for a person with a $9 million book of business is not the same position as a person with a third of the salary and a bunch of cold call potential clients.
Right.
So this was a very famous case in 2011, and Mike wound up winning.
Very nice.
We have a situation that's in the medical industry. That there's a gentleman named Adam, and he was hired by SoCo Hospital as the assistant director of nursing. Upon accepting the position, he notified his employer of his upcoming military service obligations. The following month, he received 2 weeks of training. When he came back to work after training, his supervisor told him that his military training absences are frustrating. Another training comes up a month or so later, and he timely notifies his employer about it. At this point, his employer said to him, I don't think this is the right job for you if you can't make it a priority. 2 days later, his supervisor told him that he wanted to demote him because he was leaving all the time and can't commit to his job. Now, these should all be like red flags and bells and whistles going off in your head. Adam now quits his job. What do we think happens?
He shouldn't have quit his job. He should have actually challenged that demotion.
Well, it's still, we're still waiting on that. So we'll talk about it a little bit more, but these are
Sure.
the types of scenarios and these are the types of discrimination that people encounter in the workplace based on their military service without maybe realizing that this is discriminatory. Wanda was hired by Acme Security as a security guard on March 1st. She's also a member of the National Guard. On March 3rd, she told her supervisor that she had to report for military training drill on March 7th. But her supervisor had already put her on the schedule for March 7th. So on March 7th, she reported for military training and was fired on the same day for failing to show up to work.
Wow.
What do you think about that?
That's also violating her rights.
Right. Do they have a right to fire her because she didn't show up for work?
No,
And what about if she hadn't given notice?
no.
Okay. We are now turning over. These were just a few short examples. I'm sure you all have encountered others or friends of yours or people you know. So I'm going to turn this over to questions and answers, and we are going to put Brian back on the stage to assist with the questions and answers. If anybody has questions after this presentation, my email address is here, Karen@hertzlegal.com, and Brian can be reached at blawler@pilotlawcorp.com. And you can also reach out to Andrea if you would like to, if you don't get this information, you are free to contact Andrea and she can put you in touch with us. So if anyone has any questions at this point, the stage is open.
So I have a question. You mentioned something about timely manner, giving an employer notice on a timely manner. And I wanted to know who defines what timely manner is. Or also, does it go by state? Does it go by employer? Who has the authority in defining timely manner?
So it's a federal law. I'm going to let Brian answer, but I'm going to say that it's a federal law, so it's not by state. And timely is kind of like, what is a reasonable person? But Brian, you want to speak to that?
I mean, thanks again, Karen. You hit it earlier. It depends. Service members get involuntarily recalled all the time. Certainly some occupational specialties like the special operators, more so than others, and they just go. So if you don't have timely notice, and in fact, the notice can be after you've left if it was unfeasible to give prior notice. Like you have a beeper and you're one of those guys that wears black pajamas and go to weird places that nobody knows about, and you get on an airplane in the middle of the night. If you didn't have time to give your employer notice before you left, that's okay in some circumstances. Other times, if you know you have a mobilization coming up where your entire unit's being mobilized, it's very rare that would happen overnight, and that time period would probably be longer. There's a Department of Defense directive, more of a guideline than a rule because it doesn't trump the federal statute, and it suggests that in every case where it's possible, 30 days notice is sufficient. Well, it's not always possible. In fact, it's rarely possible. I mean, think about March of 2020, COVID-19 happens, and tens of thousands of guardsmen and women and reservists got activated to deal with the pandemic response. A lot of those folks were gone in the blink of an eye. And I think I heard somebody ask earlier, we were talking about Tom, that he had to provide his orders before he left. And that's not correct. Actually, you don't have to provide your orders before you leave. You never have to provide documentation of what you're doing before you go. You only have to provide that documentation upon return for periods of greater than 31 days or 31 days or more. And that's solely to make sure you've checked off those five criteria, right? Specifically that, you've timely applied for reemployment, that you were honorably or not dishonorably discharged, and that you actually did serve. I mean, the employer certainly has a right to do that for longer periods of service. So yeah, timely's kind of a moving target.
Mhm.
Just another question, just to like, have you all ever encountered like a hearsay situation, right? Where someone verbally advised their employer, but never followed up in writing, like let's say an email. Sometimes people don't have the wherewithal to say, I got to put this in writing. And then it comes down to a hearsay, right? You told your employer, you didn't put it in writing. Is that an issue down the line, right? So if you have a conversation with your employer, never put it in writing, could that employer potentially turn around and say, well, he never gave in a timely notice?
Do it
Would
all
you
the time.
advise that it should be put in writing, in other words, or? I mean,
I think if someone came to me before he or she was activated and said, how do I broach this with my employer? I would certainly suggest doing it in writing. In fact, I always do. And, BCC yourself or something to that effect, but there's no requirement to do that. Verbal notice is plenty.
Right.
And to further that question, yeah, I see it all the time where the supervisor who was told about his employees pending military leave has come back and it has even said in a few occasions in deposition, well, he or she didn't tell me that. And then we come back with, of course, well, they're going to testify that they did. So you're calling your employee a liar. Well, I'm not really saying that. So we've not run into that situation where the employer has won in that situation. And it obviously it's kind of a backpedal move to try and cover their tracks, for lack of a better term. But yeah, verbal notice is fine. Verbal
and
notice the
here's-
day before it happens is fine. In the case of Wanda, that's a real world case. Told her supervisor 4 or 5 days before drill. Interestingly enough, she had actually given them her year-long drill schedule when she was hired. So they had that information in writing. And then she reminded her supervisor, and he said, well, you're on the schedule. And she left and they fired her. That case is ongoing right now.
And I think I know the answer to this question, but I just want to, let's say you have certain, like, let's say you're a doctor. Does timely notice change then? Like if you have a position that relies on you heavily, does the definition of timely manner change?
Like Brian said, it's depending on.
Not at all. I mean, look, I'm empathetic to an employer, right? We've calculated, and there are studies out there that suggest that for every reserve or guard person that you hire, you're really staffing about 1.6, because that person's going to leave periodically, and sometimes it's a long time. And I get this question a lot. I actually had this question with some colleagues, friends who own small businesses, and said, well, what if this person leaves for a year and then his or her replacement comes in and is awesome at the job, and then John Smith comes back in the door, I have to retrain that person for that job when his replacement is really, really doing well? Easy answer is, yeah, you absolutely do. And well, then I'll just fire him as soon as I rehire him. I said, well, that's not going to work either, because there's a protection clause in there that protects you for up to a year for being terminated for anything without cause. So employers get what they think is kind of smart, and they start writing them up for stuff that really isn't, he or she didn't do. And then the final fallback is, well, then I'm just not going to hire them. And that is also illegal. So, there are lots of ways to skin that cat, but, timely notice is timely notice. And, if that physician, so this is a good example, that physician scheduled for open heart surgery, tomorrow, and COVID breaks out and his guard unit gets activated immediately, and they bounce and they go to wherever to provide pandemic response, he leaves, he goes. There's no questions asked about that. And it's up to the hospital or the group or the employer. Ultimately, it's up to the employer to find the person's replacement. And that kind of is a nice segue, because we get asked all the time, hey, my supervisor's telling me, yeah, it's fine if you go on military leave, but you need to find someone to cover your shifts. Not the right answer. It's the employer's responsibility to cover the service member shifts.
I have a question.
Yeah.
Hi, Brian. Just listening to what I've heard so far, the examples and so on, and what you just explained, it sounds like there's it's not, the law is not understood very well. in the civilian sector, in the employment world, at least with regard to some of the larger companies out there, or any company that has an HR, for instance, are they trained
They're
on
so
this?
ignorant.
Is there any sort of, education that's required or offered so that at least some of the companies that do have that resource can deal with this properly?
That's a great question. I'm sorry I can't see you, but thanks for it. Yeah, Userra itself
Hello.
mandates
Wait.
that employers post the employees' Userra rights. So anyone who's worked for a company, and the break room probably is the most likely place to see this. Your EEO posters, your ADA posters,
Yeah.
all those posters that are generally created by the Department of Labor. They've done one for Userra, and it is incumbent upon the employer to make sure its employees have notice of their rights under Userra. And Userra also says it's incumbent upon the employers to educate themselves. And so I started practicing a little over 20 years ago, and about 2009, I guess, was when we filed our first Userra claim, and that's all I've been doing pretty much ever since. And so we've sued mom and pops who genuinely don't know, like they're ignorant of their obligations under the statute, because as Karen alluded to earlier, it covers employees of any size. Some of you probably know that some of the federal employment laws only apply to companies over a certain size. And I don't know what they are because I don't do any other type of law, but some of them, I think 50 is the threshold number. I think one of them is 15, where if you are smaller than that, that federal statute doesn't apply to you. It's kind of a head scratcher for me. I feel like they should apply to everyone anyway, but Userra applies to everyone. So with the mom and pops, oftentimes they just don't know. And with the Fortune 500 companies, they absolutely know, and they choose to ignore. And two cases in point: one, FedEx, probably one of my best cases and most successful cases of all time, was against FedEx. FedEx was started by a Marine Corps officer, retired Marine or Marine pilot, and we've sued them a few times. And Wanda, who's still up on the screen, I have no problem saying this because it's an active case and I have no love lost for this company. Acme is Amazon. Amazon fired Wanda, and they fired a bunch of other people. We're in the middle of this lawsuit right now, and we're fighting tooth and nail over how many people Amazon has fired for doing exactly what happened to Wanda. And as you can imagine, Amazon is not super thrilled having to give us that information. I think this one's going to have to go to the judge, and she is going to tell them to give it to us because they have to. So I know it's a long-winded answer, but did that answer your question? So yes, I think a lot of companies still just don't know, which is weird because the statute's been around for going on 30 years now. But a lot of them choose to ignore it, and basically tempting or taunting the employee, the vast majority of whom are junior enlisted service members that are probably not well educated or very sophisticated, and daring them. What are you going to do about it? You're going to file a federal lawsuit against us?
Yeah, and
fortunately, Userra. Go ahead, please.
Oh, I'm sorry. I didn't mean to cut you off.
No, please.
You were just reading my
Please.
mind when you said that. It sounded like to me that they're betting that the lawsuits will not come.
And
Really
that is the
disrespectful
bet, and that is why
harassment.
Userra is. I'm sorry, who's talking? So,
Sorry, go on.
yeah. So that is the bet that the companies are making, right? And like any Fortune 500 company, it's a bottom line bet. And Userra is crafted specifically so that service members, even younger enlisted with not very much money. I don't know if you've kept up with the DoD pay tables lately, but they don't make very much money, and they're generally not filling higher level management positions in the civilian sector, because the majority of the Defense Department is enlisted. It's a pyramid. Probably all seen that. So Userra is a fee shifting statute, which means our fees come separately from whatever we're able to recover for the service member. And so I've taken cases for as little as $1,500. A $10 an hour plumber's apprentice. This is a true story. Abilene, Texas, or Amarillo, Texas, gets hurt on a weekend drill. He comes back. He shows up Monday. He's on crutches. He says, "Hey, I can't go out on the truck today, but I'll gladly sit and answer the phones." And they said, "You're useless," and they fired him. And he got a new job, I don't know, about a month later. And then he was out, whatever, about $1,500 in lost wages. Well, we filed that lawsuit because what's going to teach that company that what they did was wrong? And we got our young man 1,500 plus a couple, and we got a fee component separate from that. And that's why, the service members are incentivized to file this. And further to that point, if you belong to a union and there's a union grievance process that you have to follow for every other complaint that you have against the company, you don't have to do it in a Userra case. You go right to federal court. Arbitration agreements are a different story. I don't want to dive down that rabbit hole. Sometimes they're enforceable, sometimes they're not. But yeah, and we find the worst offenders are the big companies because they think they can get away with it.
Very good. Thank you very much. That's excellent information.
I would like to also just point out that I've worked with a lot of different employers in my career, and it is shocking how many employers don't know. They know that you can't discriminate because of age and gender and religion and national origin, and even it's in their military status, but the employers, and a lot of it is poor training in the HR departments. They don't know that this exists and that it says you can't discriminate against people because of their military status, but they don't know there's an actual law that prevents it. So I think it's also a lot of ignorance and a lot of arrogance. So I think it's a little bit of both.
And that's a great way to put it. Ignorance and arrogance. And I'm going to throw this out to the room and to everyone who's watching on Zoom. What do you think is the most frequent first response we get from every single company sued? Now go back to 9/11 and think about what, just think for a second. What do you think we get most often as soon as we file a lawsuit? What response? We love our military. We wouldn't discriminate against our military. Okay, that's great. That's great. You have a flag on Veterans Day and you wave it and you do all those fun things. It doesn't mean you didn't discriminate against our client. And it doesn't mean that when you peel the onion, your policies, that's another thing. Your policies don't violate the statute. Someone asked earlier about orders prior to going on leave. No, you don't have to provide them. We have found several cases and in fact had courts order the company to change their policies. When you get their employee handbook and you look at their military leave policy and it says in black and white, your leave will not be approved until you provide orders to your supervisor. Well, that's on its face unlawful. Can't do that. And we've had cases, it's called declaratory relief, where we've had a court say, rewrite that. That doesn't work.
Can I ask, this Userra applies to IRR as well? Or people, like, for example, if let's say your contract ends and then you receive, like when we were out in Iraq, a lot of people were extended and they had a job already lined up. So I just want to know if it covers IRR and people that are stop loss.
So the IRR, for those that don't know, it's the individual ready reserve. It's where you kind of sit, kind of a holding pattern between active duty or active reserve or active guard service. There aren't any requirements in the IRR to do anything other than make a phone call once a year, right? To just make sure that you're still alive. So to the extent that you would then be activated or otherwise ordered to duty, you would leave the IRR, right? So no one in the IRR is getting active. You get activated and then you become an active reservist or guardsman or woman. I guess reservist, right? There's no IRR on the guard, but it does. But I can't envision a scenario where someone in the IRR would need Userra protection, because once she gets activated, you're now under the umbrella. So
Right.
Yes, but no. Does that make sense?
Totally,
Yep.
totally. And stop loss falls under that kind of same scenario, right?
So stop loss. So let's say you're going to get out and you have a job lined up and your EAS or end of active service or your contract is up on June 30th. You're going to start your new job on July 1st. And you get stop loss, and they're going to hold on to you until September. And your civilian job, which has already extended you an offer of employment, says we're not waiting for you until September. I would take that case 10 days a week.
Can't do it. They
Okay.
can't do it because they think
Did
they
that answer your
can. It's
question?
only an offer.
Totally,
Right.
totally. Yeah, yeah.
Interesting.
Yeah. And by the way, an offer of employment, you're now protected. And in fact, the application for employment is protected. And we have a couple of these cases. We're seeing a lot of failure to hire cases lately. I think we have 3 or 4 active failure to hire cases where during the interview process, someone in the hiring department says, oh, you're in the Guard or the reserves. Yeah, that's not going to work. Or, hey, we need you to work, 4 Saturdays a month, or 3, or even 3. And the person says, well, I mean, I can do 3. I just can't do it on this one. They said, well, you don't get to choose. If you're not available when we want you to work on a Saturday or Sunday, then we're not going to hire you. That is an actual fact pattern we have right now.
So if someone makes kind of like a comment about, oh, we're not really, we can't consider you for the position because you're a reservist, we can't rely on you, that's enough for you to file a grievance against that particular employer. I just want to make sure.
It's not a grievance, it's an actual lawsuit.
Oh, there
Yeah.
you go.
Lawsuit.
Thank you.
Because it applies to job applicants as well as employed people.
Okay.
Someone asked me a question earlier, and I can't remember, it was a gentleman a few moments ago about the lack of knowledge. And 9/11 was, we're going on 22 years ago. The statute predates 9/11 by 7 years, and really by another 54 before that. I say this to people sometimes jokingly, but tongue in cheek. As a business owner running a law firm, I don't hate that we're as busy as we are, and we're really, really busy. But as a retired Marine Corps officer, 17 years of my 28 was spent in the reserve component. It's irritating that we're still doing this, and that companies still don't get it. And the irony is furthered because the worst offender out there, the worst employer offender out there by leaps and bounds is the federal government.
Mhm.
Not even close.
Wow.
Not even close. Yeah. That's the wow factor. That's the one that normally gets people to say, you got to be kidding me. I said, I wish I were, but
Yeah.
I would say a third of our client or our cases right now, and it was as high as 50% within the last couple of years, are federal employees.
That's incredible. That has got to be somewhat of an embarrassment, I would think, to someone, but
I'll tell you how bad it is. A couple of years ago, we represented a brigadier general, 1-star general, who worked for the exact same command as a civilian. Now, this is not a National Guard dual status technician. This gentleman was a civilian, GS-15, might have even been an SES, and he's a brigadier general in the reserve. So he sat at the same desk, performed the exact same job, worked for the exact same people, changed his name tag on his desk on the weekdays and the weekends from Mr. to General. And we filed a lawsuit against the Department of the Army. He was a civilian Department of the Army employee and an Army Reserve general. And they weren't happy about his reserve service, which is the head scratcher of all. That's the weirdest one I've ever had.
that's absurd.
Insane.
That's absurd.
That's insane.
You know what, we have another case where an employee was a state police officer. And the head of the state police wrote a letter to his commanding officer complaining that he'd been deployed too many times. In writing.
Oh my
State
God, that
police.
is so
Yeah.
crazy, lack of common sense.
Okay, it's Paul's turn. Paul has a question?
Paul, do you have a question?
I do. Thanks, Andrea. Hi, Brian. Thank you for being here tonight. Semper Fi, by the way. I have a question.
Well, thank you.
Does Userra cover people who are not fired from the job, but who get harassed because of the military obligation?
Oh, good question.
Yes.
It does. It didn't until 2011. Right, so the statute was written in 1994. It's an anti-discrimination statute. And one would think that all the anti-harassment, anti-discrimination provisions that go along with the ADA, the ADA, Title VII, Title IX, Civil Rights Act, all those prohibit discrimination or harassment based on your protected status. And Userra is the same kind of a statute. So my first case, the one in 2009, was a class action against Continental Airlines. And we alleged that Continental was screening, selectively discriminating and harassing, and at times terminating, or failing guys in simulators, right? Because they oh, you're going to be gone so long, we can't overtly come out and send the email that says you're in the reserves, you're fired, because that would be brilliant. Read the sarcasm, brilliant. So they would do it. They would do it differently, and they would, call the into the chief pilot's office on off days, make them fly there not on their own dime. Clearly, they could fly on the airline for free, but just an inconvenience factor. And then they started calling the commands, the military commands where these guys would work, and assistant chief pilots would call these colonels and general officers, say, "Where's so and so, and is so and so actually working this weekend or performing military duty?" And the commander would say, "Well, who are you?" "I'm his boss." "Well, not this weekend, you're not. I am. So goodbye," and hang up on him. And so we brought that lawsuit, and we lost it in Houston, Southern District of Texas. We lost that lawsuit, and we appealed. And the reason that we lost it, the court said, there's no anti-discrimination provision. There's no anti-harassment provision. You can be harassed based on your military status, according to the Southern District of Texas. So we appealed that to the Fifth Circuit Court of Appeals in New Orleans, not the most plaintiff-friendly employment venue, I will add. We got an oral argument. I was actually deployed. It was my last active duty deployment. I was overseas. I was in the Middle East, worked for a great general officer. He said, "That's your job. You go back. I'll give you a week off. You go back and argue that case." And I did. And the Fifth Circuit agreed and said, there's no cause of action for harassment based on your military service. And we were all scratching our heads going, this doesn't make any sense. Well, Congress got wind of that, and the Department of Labor got wind of that. And we had some role in doing that. We called up some folks that we knew in Congress and on the Hill, and then the Solicitor General's office and at DOL. And because of that opinion, it's called Carter, C-A-R-D-E-R versus Continental Airlines. Because of that opinion, Congress rewrote the statute and said unequivocally, retroactively, it's an anti-harassment statute. So we lost that case, but Congress rewrote the law. So I guess in one way we won. Then Continental merged with United. We filed that again, and at the time it was the largest class action settlement in Userra history. It's been surpassed, but at the time it was. So one little loss to get a much bigger win. So I have a long answer, Paul, but did that answer your question?
Yes, it does. Thank you. Thank you very much.
That's pretty cool.
I have a question. This might be like way off left field, but Userra wouldn't apply for a veteran, right? So let's
No,
say
it does apply to
it
veterans.
does. See,
Yes,
this is important to know.
it's in
because
there. It's in the
I've-
presentation.
Well, I thought it's like if you're
Veterans.
re-engaging, but I've experienced, I had an employer, and she had lots of comments about my deployment and my mental health and the ability to do my job and her doubts. And then, I ended up holding two positions for one salary, two positions. I knocked it out the ballpark, but she was harassing. Every day there was a comment about, serving in the military and mental stability and, how
Yep.
many guns I have at home. And I ended up resigning from that position. So, just giving that example, is that a case for you,
Yeah,
Sarah? Just
yeah.
confirming that for the people that will go back and listen to this recording, being very clear, you don't have to be in, you could be a veteran. Is that right?
Yeah, you can be. So take
Thank you.
Captain Torres, for example. He was still in the employ. I mean, he had been discharged from the Army Reserve. He was medically discharged, 100% medical disability, when he went back and applied to the state of Texas. He's no longer a reservist. He went back, he was technically out, so he was technically a veteran. Now, because the injury or the illness or the ailment or disability that he incurred was from his active duty, the accommodation had to be made. So we see
Oh.
occasionally folks who, and it comes up more in the PTSD realm, but people that served and a couple years later, they're not able to function fully or as highly as they were prior to going into wherever they went and saw whatever they saw. And they come back and their assertion is because of their combat related PTSD, they need an accommodation from their current employer. That person is absolutely covered by Userra. There's no question about it. I will tell you that those cases are possible. They're absolutely impossible. Connecting the dots, a few years removed from the injury or the disability, those are really tough.
Brian, I was going to ask you about that. In using Andrea's example, where she's talking about a specific harassment. You're basically, when you say it's impossible, is that the same thing there? Because it's, one person's word against the
True, it's a
others?
proof thing.
Is it, how do you deal with that if it comes to that?
And I think the young lady's name is Andrea. What she said, what I think I heard her say was, lots of different comments about my military service and my appearance and my background. And we get that. I've heard that a lot. We had somebody come in and his supervisor told him he was too, quote unquote, militaristic for that job. Like, what does that mean? Like, I don't understand that. But what we have found, what we have found is the death by 1,000 paper cuts, like lots and lots of little otherwise innocuous comments that in the aggregate probably make you miserable at your job. Those cases they don't work. Judges don't buy them. Juries definitely don't buy them. And the unfortunate reality and the dichotomy, if you will, of representing service members in cases like this who are plaintiffs is oftentimes the judges and the juries will look at them and say, you got to toughen up. You should be tougher than that. That shouldn't really bother you that much. That's a completely inappropriate response, but it's human nature. And you can't change that perception, right? And unfortunately, there is a Supreme Court standard for what hostile work environment is, and that doesn't matter if it's based on ADA, Title VII, ADEA, or Userra. To show hostile work environment, you have to show, and I will quote from Justice Ginsburg, conduct so severe and pervasive as to shock the conscience of an ordinary reasonable person. Well, what is shock the conscience? That's my standard. And too militaristic, or you're not, whatever those comments are, they just don't rise to that level. And even if it's a lot of them, it doesn't. So we've stopped taking the harassment cases where there's no other adverse action. Like, they don't say you're too militaristic, you're fired. That's one thing. That case I would definitely take. But if it's just a pattern of conduct, the death by 1,000 paper cuts, we just can't take those cases anymore, because you spend a lot of time and money litigating them and you're going to lose. I wish I were telling you this because I knew it from my crystal ball. I'm telling you this because we've lost a lot of them, and we can't do them. They're not viable.
Okay.
Yeah.
All right. I could see that.
Yeah,
That makes sense.
that's how I ended up taking two positions for the
positions,
pay of one,
yeah.
trying to prove myself. Yeah.
Yeah.
She made out like a bandit.
And that was really constructive discharge because you had no choice but to quit. It was as if you were fired.
Yes, that's right.
Right.
Thank you.
I don't want to get too off. Just a quick question about you, Brian. If I may ask, where do you practice from?
Live and work in San Diego, California.
Oh,
So I'm
okay.
San
That
Diego.
was said earlier. Okay, so you're on the way. Okay,
The Karen's on this side.
and you're on this side. Okay. Very
Born
good.
and raised in Fairfield County, so I got
Sorry?
my New England roots.
He's from Fairfield County.
Oh, he's from this neck of the woods. Oh, okay.
That's why. East Coast.
East Coast. All right.
Yes.
That's
Very.
that's very helpful. That's very informative. Thank you. I'll just say, Andrea and I are both work in a veteran service capacity. So this information is very useful. It's very helpful. Thank you.
Appreciate that. I appreciate the opportunity to be here.
Thank you.
Thank you,
Thank you.
Andrea,
One of
for
those,
putting this all together.
What was that?
Be brief. I'm one of those guys that learned a long time ago from a former commanding officer. When you have the floor, you got the two B's: be brief and be seated. So, depending on any other questions, I'm gonna close my mouth.
Okay.
Brian, thank you for joining us. We really
Yes.
appreciate your expertise.
Yes,
Very much.
truly.
Thank you,
Oh,
Brian.
just-
I don't know about expertise.
have
I don't know
one
about
last
expertise. Call it hard knocks. But yeah, I'm sorry. I heard one more question. What was that?
So I've heard historically that it's impossible to connect with ESGR. Is that the acronym ESGR?
Mhm, it's ESGR.
ESGR. Yeah.
So, and people just, they give up. And what would you, I don't know if that's in your realm, what would you suggest a person do when they just continue to reach out, call, stop by the office and no response? What is the next step to take in order to receive some kind of action?
That's a great question, and probably we should have talked about this earlier. I mean, there are no administrative prerequisites to filing a lawsuit. You can come find Karen or me or any other lawyer and file a lawsuit under Userra. You don't have to go to ESGR. And for those who don't know, ESGR is the employer support to the Guard and Reserve. It's a DoD sub-entity. It's an ombudsman service. They're there to try to effectuate a resolution between the employer and the employee without any formal grievance with anything, so the employee gets in touch with the ESGR and says, hey, I think I'm being wronged by my employer. And then ESGR steps in. I will share with you, I found them to be somewhat effective in some places, but I've met a lot of ESGR ombudsmen and some no more than others. And that's just the way it's going to work. If that's not effective, or the service member doesn't want to go to ESGR, he or she can go to the Department of Labor. DOL, so ESGR can say, I don't know if we want to get involved with that. They shouldn't really do that, but they have the option. DOL doesn't have that option. If you go to DOL vets and you file a complaint, DOL has to open an investigation. They have to have it done within 90 days. You can extend them for that, and they will write a findings letter and say where you either did or didn't violate Userra. And at that point, the service member has two options: ask DOL to refer it to the Department of Justice, who enforces those findings. Justice doesn't take very many cases. I think when we were in the Supreme Court last year, we had the statistics because we argued it, because it was important, because the state of Texas in the Supreme Court case was saying, look, they don't need to have the right to file a private lawsuit in the state of Texas. They can go to DOL. And we had the stats because the Solicitor General from the United States was on our side. So we had the stats, and it was some ridiculously low number. I think 13% is coming out of my head. How many cases that justice will actually take of the ones that labor finds have merit. Justice won't take a case that labor says doesn't have merit. So they could go that way, or you can just go to a private attorney.
Thank you. Because some people are under the impression they have to follow the quote unquote chain of command and they have to go through ESGR. They just
No, that's an unfortunate misconception, because the statute's very clear. As you can't, the statute doesn't, Userra being a statute, doesn't say anything about ESGR, because that's not a remedy. That's just let's see if they can help me. The statute reads very clearly, you can go to DOL and file a complaint, and then ask justice to do it. And then the United States would file your lawsuit for you. Or you can go to a private attorney. So yeah, there's no requirement to go through any of those grievance procedures. And again, because I know there are a lot of union people out there, and we represent union members from time to time. Every single time we sue a union or we sue a company on behalf of an employee who's a union member, the company's first response is to move to dismiss the claim because they didn't go through the union grievance process. They don't have to.
Perfect. Thank you so much. That's very important. Thank you. Thank you.
Okay, so thank you.
Put me into all y'all's happy hour and dinner time and all that stuff. I want to close mouth.
Okay, thank you.
Thank you,
If
Brian.
anybody has questions, you can get our contact info from Andrea.
Okay, and we will have that posted up. Thank you all for attending or going back and watching this video. Thank you. Good night.
Thanks so much for having me. I really appreciate it, guys.
Thank
Have a good
you.
night.
We appreciate you. Thank you. Thanks, Paul.
You're welcome, Andrea.
Bye, Paul. Thank you.
I'll talk to you tomorrow.
Very good. Thank you.
Thanks. Bye.
Good night now.